Okay. Yeah. Morning. Yes. And Barry gave a wonderful introduction of IP as far as U.S. is concerned, but I would like to take it for India and maybe a few other developing countries. And it's also my duty to introduce India. Why India? So the synopsis of my presentation would be why India, the IP regimes, and then also the various specifics of IP regimes like patents, trademark, and copyright, geographical indications. So why India? And we all know that it's the largest democracy in the world. And recently, the biggest exercise on the humanity, the Indian elections, about 450 million people casted their franchise, the voting, and it's all done by a voting machine, electronic voting machine. And the highest the poll is on the Himalayas, where the polling stations reached the voters rather than the voters reached the polling station. So probably we'll be knowing the results after 10 days. And it's a liberal, very stable economy. Of course, the fluctuations would be there, depends on the global economy. And at the same time, it is stable and steady. And we have the third largest technical and scientific pool, low-cost manufacturing, and impartial and independent judiciary and election commission. And you won't find any distinction between, before the court of law, a US corporation versus an Indian corporation. You can't. The law of the country will hold good for everyone there. And of course, we are members of various international conventions like Paris Convention and PCT, as Barry mentioned, and then also Madrid Convention for trademarks. So some pictures of the recent election, and you can see the modern and the ancient, the electronic voting machine, which could withstand minus 100 degrees to plus 100 degrees. And that has been transported by an ancient transport that is the elephant, and one of the remote forest area of Assam in India. And this is the highest polling station. And here, how the missions have been transported, I picked up this because the fate of many of the candidates the balancing will be known maybe in another 10 days' time. And this is just a picture what is India is. And various statutes we have, the laws. These are the structural, the legislations we have. The Indian Patents Act of 1970. Before that, we had the Patents Act of 1911. That was the British Act. And then when India became independent, it enacted its own legislation, 1970. We have the copyrights, the industrial designs, and protecting the plant varieties. The varietal protection is also available there. It's not only protecting the varieties, but also protects the cultivators and the farmers. And semiconductors, what you call integrated circuit protection there. And GIs, what you call geographical indication or appellation of origin, which is not known in the United States, but we have a legislation to protect the GIs. Any product, agro or industrial product originating from a particular territory or a region could be protected under this act. And we are members of almost all international conventions. TRIPS is a trade-related intellectual property. India is a member of that. And there are supporting legislations. We have the Biodiversity Act, and we do have an Information Technology Act to govern how to manage the flow of information. And also, Very soon we might be having a utility model or petty patent protection. It's not a law there. The bill is pending before the parliament, and parliament would be dissolved in a few days' time. We'll have a new parliament, then probably we might have this act. And India is examining a searching authority as far as PCT is concerned. So the structuring, how the offices are functioning there in India, and how the court systems. We have 4 patent offices in 4 corners of India, and then here is one near Bombay, Mumbai. There's another one. Delhi is here, and Calcutta is here. Though there's a single statute, but there are 4 patent offices to govern, to regulate the patents filed in India. The patent granted by any one of these offices would be effective in the whole of the country. Likewise, we have 5 trademarks and separate corporate registry we have. And any appeal from the Intellectual Property Office will go to IPAB, that is Intellectual Property Appellate Board. We have that. And that is an independent board apart from the Patent Office. Any appeal from the Patent Office will go to this board. Then court system, we have the Supreme Court, that's the highest court of the land, which is in Delhi, New Delhi, and we have every state. India is a federal structure, and every state has got its own high courts. And then underneath, you have the district courts. This is how it's been structured. And the patent filings are really increasing it. You can see that in a matter of 5 years, they increased to the extent of about double. So this is what is happening now, ever since India introduced the product patent system. So patents are available for all areas of technologies. 10 years back, 15 years back, we had a problem. No product patents. Only process patents, and the term was only 7 years from the date of filing. Many times when you get a patent document, what you call the title date, the term would have already expired. But now it's different. The term is 20 years, early grant, and it's available. The patent protections are available in all areas of technology. There are certain exceptions, and I will just show the exception, what are those exceptions are. These are the non-patentable exclusions, what we call an artificial exclusion. No matter they are novel and inventive, but still they are not patentable because of public policy. This is in India. Like methods of treating human beings and animals is not a patentable subject in India, whereas that is patentable in the United States. And here is another distinction where software, computer programs per se, algorithms, business methods, and mathematical methods are not patentable here. So we need to have a little careful that if there is a business method, you can get a patent in the United States, but you will only get it in India. Any inventions relating to atomic energy is not patentable here. So this is one of the major exceptions between US practice and Indian law, where any second use, or what we call a new use of a known substance, is not patentable. This is one exception against the whole world in India. For example, if I have a molecule, or I can say a salicylic acid, which is aspirin, which cures my headache. But if I use aspirin, or I have now made an invention that it cures my arthritis. And that is an invention, but unfortunately, that's not patentable in India. The rest of the world, you can get a patent. Why? Because of the section 3D, which says that any new use of a known substance is not a patentable subject matter. That's what. And in case of second generation products, sorry, I'll be a little more technical, because patents are techno-legal. And when you say second generation product, what does it mean? We have new chemical entity, and thereafter we come out with patents for polymorphs and derivatives and metabolites, other ingredients. We come out with those products. And in India, if there are second generation products, we ought to show a substantially enhanced efficacy of the product, then only you get a patent. That is one exception in India. So whenever we have a second medical use, it becomes more or less a non-patentable subject matter in India because there are so many exclusions regarding second medical use. And second medical use is patentable the rest of the world, but not in India. Why? Because you have a second medical use, and here is the first objection which comes, that any new use of a known substance is not patentable. And you direct the invention into a sort of a product, a composition. Then what happened here? It says that any mere admixture is not a patentable subject. And now we direct the claims to a method of treatment, like treating arthritis using salicylic acid. And that's patentable in the United States, even in other places. But when I direct my claims to a method of treatment, then what happens? And we have another exclusion which says that any method of treating human beings and animals are not patentable. So literally, the second medical use is not a patentable subject in India. If you're able to cross through all those things, probably you might be able to get a patent in, but it's extremely difficult. Some of the peculiarities, no patent term extension, patents for 20 years from the date of filing, and no patent. If there's a delay in prosecution, unfortunately, that will not be compensated. So no patent term extension, that is possible in the United States. And there are higher bar, as I said, you need to show substantial enhanced efficacy in case of second generation product. That is what. And no patent link between the regulatory authorities and the patent office. And best mode of the invention will have to be disclosed. And we have some of the exceptions like Bolar provision, which is akin and specifically for pharmaceuticals. And some of the formalities, there are important formalities is needed. In case of biotech inventions having biological material, one of the Indian specific requirement is that you ought to show the source and origin of the biomaterial in the patent text. That is one of the peculiarities of the Indian law, the Indian patent law. And any inventions made in India, if they wanted to first file your application abroad, you have to get a foreign filing license from the Indian Patent Office. And we have the post and pre-grant oppositions. They're all inter-parties. And then, so we need to be a little careful. If there's a post-grant or a pre-grant opposition, there could be considerable amount of delay in grant of the patent. Now come for the design, industrial design. We have, oh, sorry, it makes. So I don't need to talk, the computer talks for itself. And the term, we have 15 years protection, 10 years, and which ought to be renewed for 5 years. And where the shape of an article, which is eye-appealing, aesthetic shape of an article is protected here, and it's a statutory protection. If you don't get your design protected in India, you have no right at all. Here's here's a case law, recent case law, between the world #1 luggage manufacturer, Samsonite, and world #2 luggage manufacturer called VIP. And you can see the luggage. They are similar. They look alike. Probably may not be identical, but they are substantially same. And one is VIP, another one is Samsonite. And when Samsonite released the product, VIP started manufacturing the lookalike product. And Samsonite went to the Delhi High Court and got an injunction, what he called ex parte injunction, where the other side was not there. The judge gave an injunction merely seeing the product. But the VIP defended that where is your right, on what basis an injunction was granted, because they had not filed the design. It is an external, aesthetic, eye-appealing feature, and it is a statutory right. That means you ought to have your design registered in India. Unfortunately, the Samsonite never had their registration, and the VIP defended that they had no statutory right. They had no right at all. I have a right to copy. And the court said, yes, since you do not have a design registration in India, and then it's open to all, it's in the public domain, people can copy it. And they also had said we had a shape of an article protected, but they said that it's a new product, recent product. There is no secondary meaning. The shape is not been still recognized by the consumers and customers. Therefore, you do not have a right over that. The trademarks, now I'm switching over to the trademarks. You can have not only the conventional trademarks like words, signature, etc., but also three-dimensional shape of an article. Coke bottle has been registered in India as a trademark. And then also the Tarzan's yell has been registered as a sound mark in India. And well-known marks have been recognized. For example, if Coke is a well-known mark, and then it's also protected for even dissimilar goods, need not for soft drinks, but also for other things. So therefore, in India, Coca-Cola cannot be used for my garments, or can't be used for my footwear, because even the well-known marks have been protected even against the dissimilar goods, other goods. And we have collective mark and certification marks as well. Some of the marks here, and domain name protections are available. And here is a passing off right. Even though you do not have a registered trademark, you can still avail the common law protection like a passing off or a passing off right. And here is a case where the Benz got a registration, and one of the Indian company was manufacturing the undergarments in the name of Benz. And the tri-star Benz logo has been very innovatively shown here. That's a way. And this is the Indian logo, the VIP Benz. And the Delhi High Court said ex parte injunction. And then, I mean, it's not that the Benz car, they're losing money because of these guys are selling undergarments under name Benz. And then it's not that no, people don't buy cars because of this. It's not so. But the court has adapted a concept called dilution, or dilution of the mark, that when well-known marks are used for various kinds of goods, the mark loses its value. And as a result, no, you can't use the well-known mark even for dissimilar goods, and that tantamount to cheating the public, and then also making illegal profit out of a well-known mark. Some of the remedies and intermediate liabilities. I'm now coming for copyright issues, where the various internet providers provide the platform, and what sort of liabilities are the intermediate service providers. And under the Copyright Act, they have absolute immunity, so long they don't store the information. They don't create it. They have no rights over the contents of the matter which passes through the platform, there's no liability at all. And a very effective border enforcement system we have. If you're a registered IP owner, you can enroll yourself with the customs authorities so that the products could be stopped at the customs level. And the customs official will call and tell you that the trademarks of this particular nature is entering the country, come and check it out. Copyright. And we have the original work and then the derived work or derivatives of that. The protection for corporates, 60 years. And as the US law that it is not mandatory to have the copyright registered. By virtue of creation, you can get the right in India. And India is also a member of Universal Copyright Convention and then also Berne Convention. So you no need to have the registration in India. But registration we always recommend because of the evidence. Because who was created first? So when you have the registration, that's the prima facie evidence of the creation of your copyright. And in case of others, lifetime plus 60 years. The ISPs, there's a total exemption for the contents of infringing, any infringing copyright matters there. However, if you provide a link or a storing facility, then the intentions will count. Whether you have done it intentionally, then you are liable for copyright infringement. Yet another topic, I have probably a few minutes. This is called the GIs and geographical indications. What does it mean by it? It refers to a product which comes out of a particular country, region, or a territory, having certain particular properties and characters and features. For example, you have champagne, which is a well-known GI. In India, we have very, very well-known GIs like Darjeeling tea, basmati rice, and many other industrial products. These GIs are relating to the products. They are tangibles. They're not for the services. And you know that the GIs relates to the goods manufactured in a territory, country, or a region, having certain particular characters, and it's been there like that for years and years. Here is a distinction between the old world and the new world. Like China, India, Europe, they have all recognized the GIs, geographical indications. A product, it can be agro, natural, industrial product coming out from a particular territory, region, or a country. And it has been statutorily protected. And here is the basmati rice, the Darjeeling tea. And the rice comes out the sub-Himalayan regions of India or Indo-Gangetic plains. It has got a particular character, like long, slender, aromatic rice, cooking, elongation on cooking, etc., etc. Those characters are used by the agroclimatic condition of the Indo-Gangetic plain. And so the protection is a statutory protection. It's a community right. It's a right of all the people who deal with the product in the particular region. And so the cultivators, the traders, and the processors, they all get the right. And it's a registered right, and then it's very well protected. So some of the recent cases, the Scotch Whisky Association was able to stop people who have been misrepresenting the Indian whiskey to be a Scotch. And this is what some of the cases, the expressions that we have stopped it. And of course, we know that the Shakespeare said, "Rose is a rose, You might call it by any name, but we don't agree with that. Rose is a rose only when you call rose as a rose. And if you call rose as a lily, we don't accept it. That is what here it is. Scotch is a Scotch, and a champagne is a champagne. And in India, there was a case, there were two cases. One, they were manufacturing a sparkling wine. It's called Indian champagne. But the judge said that, of course, the defendant argued that we're not deceiving the public and the consumer and customer because we are putting Indian. So it's not that it originated from France, the Champagne district of France. But the judge said, fine, but where the word, the champagne from? And then you please remove that word. You have no right to use the word. It is deception. It causes confusion among the public. And then also, you are making illegal money out of that. You are not supposed to use that. So he injuncted it. And then also another recent case, which is against a U.S. corporation, is called F. Corbel and Brothers. They were importing into India two kinds of sparkling wines. The one is called Californian champagne, and another one was Russian River Valley champagne. And these products are used in the United States for more than 75 years. They imported those products into India, and then instantaneously, the judge gave an ex parte injunction against these two wines or the champagne, because these products are not originating from the Champagne district of France, and you have no right to use that. And this is a protection here. So more or less, I have finished my time. You know, India, we invented zero. We taught the world how to count. I should stop now. So when you come to India, we'll serve you Scotch there. And there won't be any difference between the Scotch from Scotland and India. Thank you.